All right, well, welcome everybody to our annual Constitution Day event. We put this event on every year on behalf of the College of Humanities and Social Sciences. The idea is to have a presentation on a topical issue that relates to the Constitution, present multiple perspectives on the issue and think it through and reason it out and come up with some conclusions on how we think about it. We're honored to have with us today Professor Alan Garfield of Delaware Law School of Widener University. Professor Garfield is a distinguished professor of law and expert in the Constitution, and he's here to share with you his presentation on When Law and Religion Collide, discussion of the Masterpiece Cakeshop versus Coloradio Civil Rights Commission case, which many of you, I'm sure, have heard about already, and if you haven't, you're about to learn a lot about it. Before I give the floor to Professor Garfield, let me just point out that Rowan University and Delaware Law School have a great history together. We share a 3+3 law school program where you can, if you get admitted to Delaware Law School after completing your major and about 3/4 of your undergraduate electives and all your core requirements, have your first year of law school count as your final year of undergrad, and therefore complete your undergraduate degree and law degree in 6 years instead of 7. In addition, Delaware Law School is having an open house on November 8th at 1 o'clock, goes about 1 o'clock to 4 o'clock. So anybody who's interested in law school and interested in applying to Delaware law should feel free to attend that event. Let me know if you have any questions about that. We're also happy to have with us the Dean of Admissions and Enrollment Management at Delaware Law School, Dean Barbara Ayers. If you have any questions about Delaware law after this presentation, you can certainly come and talk to Dean Ayers. So, without further ado, thank you once again, Professor Garfield, for joining us here at Rowan. I'm going to give Professor Garfield the floor. Thank you very much.
Thank you. All right. So, thank you. Better wait to hear what I say. Now, yesterday was Constitution Day, September 17th. That marks the date in 1787 when the framers signed the Constitution in Philadelphia. Okay? And one of the things I want to thank Rowan for inviting me to help you mark Constitution Day, and especially Professor Weiss for inviting me. Now, you may wonder, like, what are we supposed to do on Constitution Day? You know, the natural thing is we should be celebrating the Constitution. I mean, you know, people probably think, hey, we got the best Constitution in the world, and we got the best Supreme Court with the best jurisprudence in the world, so we should have a celebrate it, right? But you guys know that it's a little more complicated than that. Okay? When they did the bicentennial of the Constitution, 200 years from signing the Constitution, they're like, we got to have a giant party to mark the occasion. And everybody was in a celebratory mood, and Thurgood Marshall, who's that? First African-American Supreme Court Justice, and also as a lawyer, the lawyer who, with the NAACP Defense Fund, brought the major cases challenging segregation in the South, including Brown versus Board of Education. And he said, you know what? I'm not in that celebratory mood. You know, it doesn't strike to me that what the framers did in 1987 reflected such brilliant genius. In fact, if you go read the Constitution, the original Constitution had protection for slavery baked into the document. Congress for 20 years couldn't ban the slave trade. It had the Fugitive Slave Clause saying that escaped slaves had to be returned to their owners. Slaves were counted as 3/5 of a person for allocating seats in the House of Representatives, even though they couldn't vote. You get the idea? It's not like the document is perfect. To this day, many more modern constitutions have clauses that you might wish ours had. Protection, a right to a clean environment, an express provision saying you can't discriminate against women, a ban on torture. There's lots of things that more contemporary constitutions have. You might say, well, maybe it would be nice if we had them. It's not as if the Supreme Court jurisprudence has been one endless march towards better and better decisions. It took, not only was slavery baked into the Constitution, but in Dred Scott before the Civil War, the Supreme Court was saying, and even freed slaves could never be citizens of this country. It helped precipitate the war. Then after the Civil War, we had the Equal Protection Clause in the 14th Amendment. Equality, isn't that great? Well, we still had apartheid in the South for another 100 years. Brown versus Board of Education wasn't until 1954. And even then, very little happened after it. And to this day, we're still wrestling with very segregated public schools, very unequal access to quality education. I think when we're celebrating Constitution Day, what we're celebrating is not that the document is perfect, not that the jurisprudence is perfect. But in the preamble of the Constitution, it says, we the people ordain the Constitution to create a more perfect union. And in Constitution Day, we're reminding ourselves that that is an ongoing process. Every generation is trying to make our union ever more perfect. Okay? That's what we're striving for, not that we reach there. We're always striving to do better. So that's what I think Constitution Day is about. Now, what we're going to talk about today is actually a wonderful issue to kind of wrestle with what's the best way to make our union better, because it's actually a very complicated issue, because it comes at the intersection of two values that we both hold dear. One is the value of religious liberty embodied in the First Amendment, right? But the other is the value of equality embodied in the Equal Protection Clause in the 14th Amendment. What do you do when these values that we cherish collide, okay? When the baker says, it's going to violate my faith if you make me bake a cake for a same-sex wedding. My religion tells me marriage is between a man and a woman. Got it? If the law forces me to do this, you're forcing me to violate my faith. But if the law allows them not to serve same-sex couples, what happens to our value of equality? Everybody else could get a cake, but businesses could refuse to serve gays and lesbians. Are they second-class citizens? You get the idea? And this issue is playing out all the time now. You got the pharmacist who's supposed to give out, whatever pharmaceuticals, a person has a prescription for, but says, I can't give out morning after abortion pills. My religion says no. You got the nurse who says, I can't work on a sex change operation. That's against my religion. You get the idea? So these issues are going to arise more and more so, as we'll see. But let's frame it in the context of this case. I say when law and religion collide, you may not know this reference here, but San Francisco had a proposition it was going to have on the ballot to ban circumcisions. Okay? Basically, the argument was it's an unnecessary procedure. The babies can't consent to it. It potentially could lead to some complications. There's no reason to do it. And they organized, they called themselves the Intactivist, and they were going to put this on the ballot to ban circumcisions in San Francisco. But could you see how that could result in the law colliding with religion, right? For Muslims and Jews, the religion might say, we've got to circumcise our boys. And the law would say, you can't. Now, it ended up not being on the ballot, but that's the kind of stuff we're talking about when law and religion collide. So let us take the Masterpiece Cakeshop case that Professor Weiss was referring to. Let's meet the players. Jack Phillips, the baker. Okay, he's got a bake shop, Lakewood, Colorado, I think, outside of Denver. Seems like a nice guy to me. I don't think he's like a gay hater at all. Okay. He just says this: I believe in Christ, and I believe it is my obligations to follow the teachings of Christ. Not just at home, not just on Sundays at church, but in everything I do, including my work. And he's had this bakery for like 24 years or something, Masterpiece Cakeshop. He considers himself an artist. Its logo is a painter's palette and brush, like he's an artist, got it? And he says, I will not make baked goods if it's in conflict with my religious values. I will not make Halloween cakes. I will not make cakes celebrating divorce. Okay? I will not make cakes with profane language on them. I will not make cakes celebrating atheism. And because my faith tells me that a marriage is between a man and a woman, I will not make cakes for same-sex marriage. Got it? And mind you, the key thing with him is, even if maybe there's off-the-shelf stuff, he makes customized designer cakes. You got it? Meaning the couple comes to him and he interviews them and tell me the whole story. Where'd you meet? We met, do you guys have a football team? We met at the Rowan football game, freshman year. And who's your mascot? Who? An owl. Okay, an owl. He says, and so he interviews them, gets the whole story. I'm going to design you a cake with the Rowan owl on the cake and little football players pictured, right? Just perfect for you. He customizes the cake. So and he says, I will not do that for a gay couple, for a same-sex couple. Well, that was unfortunate for Charlie and Dave, who were planning to get married. At the time, Colorado did not recognize same-sex marriage. This is before the Supreme Court case requiring all states to allow gays to marry and lesbians. Got it? Okay. So they couldn't get married. They were going to get married in Massachusetts, which allowed it, but then they were going to come back to their home in Denver, have a big party, and they wanted to have a wedding cake. They came into the guy's shop. It sounds like they were flipping through the pictures of the customized cake, but they never got into the design. And Jack Phillips told them, sorry, I don't make customized cakes for same-sex marriages. Got it? And it's not like I won't serve gays. You could buy my brownies. You could buy my cookies. I'll make you a birthday cake, okay? Just I can't make a same-sex marriage. That, in effect, that would seem like I am endorsing same-sex marriage, and my religion says I'm not able to. You see the conflict? Okay. Now, next part of the puzzle. There was a problem for Jack. Colorado had an anti-discrimination law. These are usually called laws that forbid discrimination in public accommodations like businesses, restaurants, and theaters, and a bakery. Okay? And the law said it is a discriminatory practice for a person to deny an individual or group because of their race, creed, color, sex, or sexual orientation, the full and equal enjoyment of goods or services of a place of accommodation. So you can understand the couple saying, he violated the anti-discrimination law. He's open for business. He is refusing to give us his services because of our sexual orientation. Understood? Without that law, the couple is nowhere. And that's important to understand, okay? Because listen to this. The 14th Amendment of the Constitution after the Civil War has a wonderful clause. No state shall deny a person the equal protection of the law. Equality. Doesn't that sound great? But note, the Supreme Court has said that only restrains government from discriminating against people based on like race and gender. Only government. Is Jack Phillips the government? No. Is Holiday Inn? Is TGI Fridays? No. Okay? It is not an equal protection violation of the Constitution for them to discriminate based on race, gender, religion, whatever. When the same-sex case decision came down, it's because they said governments, state governments, must allow same-sex couples to marry. Now you realize Holiday Inn and TGI Fridays can't discriminate. But it's not because it violates the Constitution. It's because there is legislation, statutes, anti-discrimination laws that don't allow them to do it. You got it? There's a federal public accommodation law, but it doesn't cover sexual orientation. But in this case, Colorado had an anti-discrimination law that covered sexual orientation, and Jack Phillips was arguably violating it. Understood? But you need to understand, the majority of the states, I believe, do not have anti-discrimination laws protecting gays and lesbians. So that could mean the state has to let you marry because that's the government is not allowed to discriminate according to the Supreme Court. The state, but that means you could be allowed to marry in Oklahoma, let's say on Sunday, and you could get fired from your job on Monday, refuse service at a restaurant on Tuesday, and kicked out of your house on Wednesday if they do not have anti-discrimination laws that protect gays. You got it? But Colorado did, so he's in luck. So what did they do? The couple went to the Colorado Civil Rights Commission and said, this baker at Masterpiece Cakeshop is discriminating by denying us service because of our sexual orientation. Colorado law says you can't do it. Got it? And the Colorado Civil Rights Commission agreed. And they basically said to Jack Phillips, you got a choice. You either have whatever you offer to heterosexual couples, you got to offer to gay couples. If you make customized cakes for heterosexual couples, you got it for gays. That's the choice, okay? Jack Phillips wouldn't do that. He didn't want to violate his religion. That lost him like 40% of his business. He had to fire some people. They also said, you've got to train your staff about how you're not allowed to discriminate against gays and lesbians. A lot of his staff was his family members. It's like, so he had to train them, right? So that's what happened, okay? Now, the result is this. Law and religion were colliding. The law was saying, you must serve same-sex couples. But his religion was saying, I can't do it. You got it? At least I cannot make them customized cakes. They can have brownies and birthday cakes. Got it? But it would violate my faith to endorse same-sex marriage. You got it? So that's the setup. Now, Jack is going to have to make an argument. I mean, the law is on the books saying he's not allowed to discriminate. The commission has said he's violated. He's got to make an argument. Colorado forcing me to do this violates the U.S. Constitution. And if it violates the U.S. Constitution, will that trump override the state law? Yes. Well, what constitutional right would it violate? Probably the first that comes to mind is religious freedom, right? They are violating my religious freedom. They're making me do something my religion says I don't want to do. It's like the Romans forcing Jews to eat pork. He's making me have to serve same-sex couples in violation of my religion. Got it? Well, there are religion clauses in the Constitution, in the First Amendment. Congress shall make no law there's two clauses. Congress shall make no law respecting an establishment of religion. That's the Establishment Clause. Or prohibiting the free exercise of religion. That is the Free Exercise Clause. Okay? Now, I'll just tell you as a freebie, you'll have to come to law school to know why. Even though it just says Congress, the First Amendment's been incorporated into the 14th Amendment Due Process Clause, it also restrains state and local governments. So it would apply to Colorado too. Colorado cannot establish religion or prohibit the Free Exercise Clause. The Establishment Clause, I'm going to tell you what the two clauses generally do. You tell me which one would be Jack Phillips' best argument. Got it? The Establishment Clause issues tend to come up when the government favors religion, favors, endorses, funds religion. It puts a cross on the top of the Capitol building like it's endorsing Christianity. It gives money to parochial schools. That kind of separation of church and state. They have prayers in public schools. That's the Establishment Clause kind of issues, like prayer in schools or public displays, although that one got away with it. The Free Exercise Clause has to do when the law burdens religion, right? The law says this, and says A, and the religion says not A. Got it? So for instance, if the military says, you're only allowed to wear military headgear, and a Sikh says, I gotta wear a turban, the law collides with his religion, right? If the law says Hobby Lobby, the arts and crafts store people, have to buy health insurance for their employees that includes contraceptives, and they say, our religion says we can't do that. The law collides with religion. Now, does Jack Phillips' case sound more like a Establishment Clause issue or free exercise? Free exercise. Absolutely, right? So you be the judge. Now, so it's in effect, government shall make no law prohibiting the free exercise of religion. Now, you're the judges on the Supreme Court. You've got to apply that. So in effect, it's saying the government, Colorado, federal government, shall make no law prohibiting the free exercise of religion. Understood? Do you guys know the meaning of no? Yes or no? Yeah, you're not like toddlers, right? No means no. So if it says the government shall make no law abridging the free exercise of religion, don't you think if a law burdens someone's religion, what they try and get in this case is not to strike the law down, but say they have to be exempted. So how many would say any time a law burdens someone's religion, the Constitution requires that the government exempt them from the law, right? That's what no means. No means no law. How many agree? Sort of. But wait, what if the religious practice is human sacrifice or marrying off children? You know, can the government say, I don't give a hoot what your religion is if you sacrifice, young virgins? You're going to be subject to the murder laws. I'm not going to exempt you. You get the idea? Could the government say, I don't give a hoot what your religion is, okay? That if you're going to marry off girls when they're 8 years old, we're going to subject you to child abuse laws. We're not going to exempt you, even though it says no law. And in fact, for time immemorial, the court has never said no law means no law, okay? But then the question is, when are you entitled to an exemption, and when are you not, right? And the courts basically said this. This is the easy case, but it rarely occurs. If the government passes a law that targets conduct only when it's done for religious purposes, that's downright nasty. Example, imagine Colorado passes a law. No Catholics may drink wine for communion. You guys think that's okay? Everybody else could drink all the wine they want. Just Catholics can't drink wine for communion. That sound okay? That is discriminating against someone's religious practice because it's done. At a minimum, the protection of the Free Exercise Clause pertain if the law discriminates against some or all religious beliefs or regulates conduct because it's done for religious purposes. You rarely get laws like this. Governments are usually not so insidious. The rare case was this one involving a group that engaged in animal sacrifices. And they moved into a town in Florida, and the town in Florida went bonkers. And they quickly put together a law that said you're not allowed to possess or kill animals for ritual purposes. Got it? The law everybody else could kill animals. It wasn't about animal rights. Could the exterminators kill animals? Sure. Could the pound kill animals? Yes, of course. Could you have kosher slaughtering? That's fine. Slaughtering in general, no problem. You just couldn't kill animals for purposes of ritual purposes. Got it? And the court said, you're basically allowing all this killing of animals except when it's being done for religious purposes. It's like saying everybody can drink wine except for Christians, for Catholics doing communion. Got it? That doesn't come up often, but that is one rule. Okay? And should I tell you what this group actually did for their animal sacrifice? Could you handle it? I usually wait till graduate school. This is what they did. They would take animals and kill them. Then they would cook them, and then they would eat them. Think about it. Now, sound familiar? Okay. This is where the action is with free exercise. Neutral laws of general applicability. That means laws that were not enacted to target someone's religious practice. It applies to everybody. It just happens to interfere with someone's religious practice. For instance, imagine when we had prohibition. No more alcohol. The law would conflict with people who needed alcohol for communion or for Sabbath prayer or something under Judaism. You get the idea? The law would have conflicted. It turns out there was an exemption in prohibition for the sacramental use of alcohol. So they didn't have that conflict, but that could have been a conflict. San Francisco, I gave you the example. If they banned circumcision, and they weren't banning circumcision to target Jews and Muslims, they were banning it because they thought it's an unnecessary medical procedure. There are kosher slaughtering or halal slaughtering. Under that kind of slaughtering, the animal has to be conscious when they're killed. But there are many animal rights activists who said that's cruel. Animals should be unconscious before they're killed. And there are a number of countries in Europe that ban kosher slaughtering. They say you can't slaughter unless the animal is unconscious. Did they do that to target Jews and Muslims? No, it's for animal rights they did it. The law just happens to interfere with religious practice. It's a neutral law of general applicability. What should the court do there? And basically, what the court said is this. I'm going to do this fairly quickly. They could say, you're never exempted from these laws, or you're always exempted. But instead, they came up with a kind of balancing test, where in essence, they said, how much of a burden is on the religion? How important is the government interest? So for instance, with prohibition, how important is to Catholics to have wine? Pretty important. How important is the government interest in banning all alcohol? Do you think under that balancing, they should have an exemption for wine? But how about human sacrifice? How important is the government's interest in making sure people aren't murdered? Pretty important. No exemption. That was kind of the logic. But the court ultimately rejected that. They said, this just is not feasible. It's balancing out apples and oranges. How do you balance? If the Sikh soldier says, I have to have a turban, and the military says they can't, how important it is to a Sikh to have a turban? Could the judge say to them, show me in your books where it says you have to have a turban? Could the judge do that? Could the judge say, well, I don't think it's that important to Sikhs? How could he possibly second guess them? You get the idea? And then how do you balance that against the military's interest? Same thing. Some fundamentalist Mormon family says, our religion says we have to have polygamous marriage. How important is it to them to have polygamous marriage? If they tell you it's important, can a judge second guess it? How important is it for the government not to allow it? And it's like, I don't know how you balance these things. And eventually the court got rid of that balancing test and basically said this. This is in 1990. He says, just look at me instead of that. He says, this balancing test is for the birds. This is Justice Scalia, a conservative judge. He says, on the one side of the scale, how can you possibly question what the believer says? If they says it's important to their religion and a burden, how could you second guess it? Oh, I don't think it's that important for a Jew to wear a yarmulke. How do you second guess that, right? And he says on the other side of the scale, we're balancing apples and oranges. So he ultimately came up with the current rule. Neutral laws of general applicability do not violate the First Amendment. In other words, if there is a neutral law of general applicability that burdens your religion, the Constitution does not require that you be exempted from the law. You're bound to it. What are you supposed to do then? Well, what Scalia says is go to your legislator and ask for an exemption. This had to do with Native Americans wanting to use peyote. He said, go to your legislator and see if they'll give you an exemption. You're not entitled to one under the Constitution. That's the current rule. So I'm going to skip ahead to this. Let's go back to Jack Phillips. Colorado has an anti-discrimination law. Businesses are not allowed to discriminate against people based on their sexual orientation. Did Colorado enact that law to target Christians who believe they can't serve same-sex couples? Is that why Colorado enacted that law? Do you think? Or is this just a neutral law, applies to everybody, that they thought discrimination is bad? So when Jack Phillips tried to it violates the free exercise clause, the Colorado case said no. Colorado's anti-discrimination law is a neutral law of general applicability. Requiring Jack to comply with the law does not violate his free exercise rights. In other words, he didn't have a good religious freedom claim under the free exercise clause. It's a neutral law of general applicability. So he had to say, all right, so far I'm stuck. I got to abide by this law, and I don't want to. It violates my faith to have to serve same-sex couples. Is there some other provision of the Constitution that could be violated if he's forced to make these cakes? And the answer? He tried freedom, whoa, going the wrong way, freedom of speech. Huh? What would his argument be? His argument was basically something like this. He says, I am an artist. And when I make these customized cakes with the Rowan owl and the football players, I am an artist, and art is expressive. And if you force me to make a cake that basically says, I endorse same-sex marriages, you are forcing me to say something I don't want to say. And it violates, freedom of speech is violated, one, if they don't allow you to say something. They censor you from saying, you want to say, I think Trump is a whatever, and they don't allow you. That violates your free speech rights. But it also violates your free speech rights to force you to say what you don't want to say. So he's basically saying, I'm an artist. My cakes are expression. And making me make a cake for a gay couple would be forcing me to say what I don't want to say. Do you understand? Let's take it step by step. Do you think, so he's saying, my cakes are expressive. This cake's saying, congrats on your marriage, happy birthday, whatever. Is art speech? The First Amendment just uses the word speech. Do you think art is speech? I mean, imagine, the Barnes Museum in Philadelphia, right? They've got a lot of Renoir paintings. A lot of them with Renoir nudes. Let's say Philadelphia passed a law that said, we don't want children in the public exposed to nudity in paintings, and said to the Barnes, you got to cover over this nudity. Do you think that'd be Barnes would have a free speech issue here? Right? No doubt. And in fact, the Supreme Court, Justice Souter in a case made it clear. The First Amendment, artwork is expressive, it's speech. He said even the work of Jackson Pollock is unquestionably shielded by the First Amendment, even though I have no idea what that's saying. But he said its art is expression. Got it? Now, that raises the question, what about, are cakes expressive? Are Jack's cakes art? Are they expression? He's trying to say they are. Does the fact that it's food mean it can't be art and expressive? I mean, it's true, when Michelangelo made the David statue, it wasn't made out of bean dip, that you could eat. But does it matter that it's cakes? Could that still be speech? So Jack's argument is, I am an artist. I happen to do it with sugar and flour, but I'm still, when I customize a cake, expressing a message. Well, you guys could decide for yourself if he's an artist. He's even got an artist's palette for his symbol. So, step one, he said, my pastry creations, my customized cake is expressive, is speech. And if you make me make a cake for a same-sex couple, you are making me say something. In effect, I endorse this marriage when I don't want to say it. You're compelling me to speak. And he had good Supreme Court precedent to back him up. Classic case, the Pledge of Allegiance. Can public schools make kids say the Pledge of Allegiance? No, they cannot. They cannot compel them to do the message, to say a message if they don't want to say it. Okay? This decision was actually in the midst of World War II, fighting fascists. And even then, the court said, you can't force them to say the message. They said, in Europe, we're dealing with fascist countries that force obedience to the nation. We're not that. Okay? And force people to pledge their obedience. We don't do that here. A case you also probably are familiar with is the Boy Scout case. The Boy Scouts said, we associate together, the members and the leadership, to communicate messages about values of boys and what they should do, truth, honesty, the oath. And they said, one of our messages that we express is, it's not okay to be gay. And in New Jersey, there was an Eagle Scout, a former scout, who was working as a scoutmaster who was going to Rutgers, and he was gay. And it came out in the press, he was interviewed, and as a gay activist, the Boy Scouts found out and said, you can't be a scoutmaster anymore. You can't be a scout leader. Because our message that we're trying to say is it's not okay to be gay. Forcing us to include you would interfere with our message. And the Supreme Court agreed. Okay? So now we've got this situation. Whoops. We've got this situation where Jack Phillips, the free exercise argument didn't look like it's going to work because it was a neutral law of general applicability. He's got to abide by it. But he's got his free speech argument. Okay? He's basically saying that baking a cake is art. It's expressive. And making me bake one where I don't want to is making me say something I don't want to. Just like the Boy Scouts, just like kids saying the Pledge of Allegiance. Understood? And so the court had this Goliath challenge. On the one hand, it had the equality interest of not wanting gays and lesbians to be second-class citizens who businesses could refuse to serve. And on the other hand, the value of freedom of speech, of not forcing people to say things they don't want to say, right? And in this case, added to the fact that they don't want to say it because of their religion. So that was the case that was teed up before the Supreme Court. Now, it could raise a number of questions, like this interesting cartoon. Imagine, the Klan couple comes to the African-American baker, and they're like, "But Bob, we want you to make our cake." Can he say, "I'm not serving you"? And if he can, what's the distinction? All right? Bob will say, "I'm happy to serve whites. You can have my brownies and my cookies. I just don't want to express support for white supremacy." Jack is saying, "I'm happy to serve gays and lesbians, brownies, birthday cakes. I just don't want to express support for same-sex marriage." Can you distinguish? The Coloradio Rights Commission said Bob in this situation could refuse to serve. But Jack has got to serve the same-sex couple. Now, mind you, there's an important difference. Businesses don't have to serve everyone who comes in your door. If you're a lawyer and some sleazy person comes looking for your services, do you have to say, "Okay, I have to work for you"? Or can you say, "I don't want to work for you"? Can an accountant do that, right? Businesses make decisions all the time. There are not laws that say you have to serve everyone who walks in your door. If you're a rental car agency and somebody comes up, "I want to rent a car." Well, how many traffic violations have you had in the last year? 5,000. They could say, "I don't want to serve you," right? There aren't laws that say you have to serve people who express views you don't like. There are laws that say you can't discriminate based on certain categories. So that is one possible distinction. Let's take another. This actually came up. I'm sure some lawyers put people up to it. In Colorado, some evangelical Christians came to bakers and said, "Bake me a cake that says God hates gays." That's anti-same-sex marriage. And the baker said, no, I'm not going to do that. And they said, the statute also forbids discrimination based on religion. So they basically said, "Hey, you're discriminating against our religion." The Coloradio Civil Rights Commission said, no, they don't have to bake anti-gay cakes for those guys. But they said, Jack does have to make it for the same sex. Can you distinguish those? You see how it's tricky? Okay. Now, and as Breyer said in oral argument, he said, this is the conundrum. If we let the baker win, the next baker might say, "My religion says you can't have intermarriages. I can't make a cake for an intermarried couple. My religion says that, a restaurant owner says, my religion says men and women can't sit together. So I have to have segregated seating for men and women." You get the idea? And he says it could go on and on and on. That religions say, I can't serve Jews, but they were supposed to have disappeared after Christ came. Right? And he says, is there a way to say the baker, if we exempt this baker, where do we draw the line so it doesn't undermine every single civil rights law that we've enacted in this country? That's the challenge. So what happened? And the answer is, between this battle of freedom of speech and equality interest. Oops. Aye. Big nothing. Everybody was watching this case to see what's going to happen. Okay? Especially, what is Kennedy going to do? Because Kennedy had been the critical fifth vote on all the leading gay rights cases, including the gay marriage. So he had strong sympathies for gay rights and not having gays treated as second-class citizens. But he also had strong beliefs in protecting freedom of speech and freedom of religion. Was he going to join with the liberals and say, Jack Phillips, you got to make that cake? Or was he going to join with the conservatives and said his free speech rights trump the non-discrimination law? You got it? He didn't have to decide it. How? They dodged the issue. He dove into the facts. Don't read this yet. And on the facts, when the Civil Rights Commission was investigating this and interviewing Jack Phillips, some of them said things like that made it feel like you're just a despicable person using your religion to discriminate. That's disgusting. One of them said, religion has been used to justify all kinds of discrimination throughout history. It is one of the most despicable pieces of rhetoric that people can use. This is what one of the commissioners said to Jack Phillips, who the court, I think, was just saying, I'm happy to serve gays, I just can't make the cakes because of my religion. Remember the animal rights case? Remember that? Is the government allowed to discriminate against religious practice? Yes or no? No, they got to be neutral. And basically they said, in the commission's treatment of Jack Phillips, they were not neutral. They were targeting him to criticize his religious practice. Justice Kennedy said, the commission's treatment of Phillips' case violated the state's duty under the First Amendment not to base laws or regulations on hostility to religion. They were downright hostile to him. But you know what that means? That means they never decided the big issue. The big issue is going to come up when you have the same facts, but the commission was perfectly neutral, treated them fairly, but just said, sorry, you got to abide by this law. It's a neutral law of general applicability. That they didn't decide. How is it going to play out? Now, inevitably, it's going to show up again in the court, and it's already working its way through the lower courts. There was just a case that came out in August out in Minnesota. A gay couple goes to a guy who makes wedding videos and says, could you make us a wedding video? And he says, I can't do it for same-sex marriages. That would be endorsing them, right? My religion says I can't. And Minnesota has an anti-discrimination law saying businesses can't discriminate against gays and lesbians. They sued. He said, this violates my freedom of speech. Is a movie speech? What do you think? You would be making me say something I don't want to. And he won. To apply the Minnesota anti-discrimination law to the Larsons is at odds with the cardinal constitutional command against compelled speech. They're forcing him to say what he doesn't. Minnesota cannot coerce the Larsons into betraying their convictions and promoting ideas they find objectionable. There was just a case, I just saw it online, a student tipped me off about it, in Arizona that just came out where somebody makes wedding invitations. Same argument, it sounds like. And they said, we can't force you to do something. Now, I'm just about done, but let me say this, okay? Two things. And then we'll take questions. The first is this, okay? This issue is going to keep coming up. It's this tension between freedom of speech and people in equality interest. The baker, I can't make your cake. The florist, I can't do the florist. Now, one question is, should the courts really treat this as speech? What about the guy who rents out the folding chairs? I can't give you the folding chairs for your wedding because that would be expressive endorsement of your wedding. Is that speech, renting him the chairs? That's pretty weak. Making a video, maybe making a cake is a little bit better. But also, is there a stretch in Jack's argument? I mean, how many times if you go to a wedding and you see the wedding cake, do you say, the baker must have endorsed this couple? I mean, does anybody actually think of it that way? Or just you think the baker got a lot of money, right? Is his speech argument maybe weaker than he's making it out to seem? In addition, even though the government ordinarily cannot regulate the content of your speech or force you to say something against your will, it can if there's a compelling enough interest. So one of the questions in these cases is this. Does the government have a compelling enough interest in making sure gays are not treated as second-class citizens that it should trump the free speech argument of the baker and the video maker and whatever? In fact, if the baker said instead, I'm sorry, my religion says I can't serve African Americans, almost everybody would immediately say, the heck you can't, okay? We've got a compelling interest in society of fighting that kind of racist discrimination. But why, if that's how we respond, if we discriminate against African Americans or Jews, wouldn't be the same for gays and lesbians? Is there some qualitative difference or not? Okay. The other thing to note is, and this is what I'll end on, there's a battle going on in this country between those pushing religious liberty rights to be exempted from non-discrimination laws, and those on the other side pushing for protection to groups that have historically been discriminated against. In the states worried about the gays and lesbians, they're passing anti-discrimination laws. In employment, housing, public accommodations, you can't discriminate. But half the states don't have those laws. Jack wouldn't have even been in a problem in those states. Got it? Okay. In the states that aren't favorable, they are not passing those anti-discrimination laws, but they're going even further. They're passing laws that say, you have the right to not provide services to someone if it's against your religion. Right now in the Trump administration, they have proposed rulemaking for the Labor Department that says that businesses, where the owners of the business have certain religious values that they want to bring to their business, we can't force them. They have to be exempt from laws that would force them to violate their religion. But, critics of that said the rule is going to allow businesses saying, my religion says unmarried pregnant workers, that violates the religion. You're fired. Workers who will not sign on to their faith, you're fired. Unmarried cohabitating workers, you're fired. Because, that's the concern on that part. The State Department, the same thing. Mike Pompeo just created a Human Rights Advisory Commission to make sure in our policies we don't violate people's religious liberties. But people on the other side are worried that's going to be an excuse to not provide reproductive rights to women, to discriminate against, gays and lesbians and transsexuals. So that's the battle, okay? That's where things currently stand. So, questions? Yes?
Yes. I was wondering at what point does hate speech as an expression cross the line?
Good. Okay. Excellent question. So listen. If the government is regulating you because of your message, as a general rule, that is unconstitutional. No matter how offensive and hateful your message, and the court has even said hate speech is protected. Okay? On the other hand, the court has also made it clear that if you threaten someone, I'm going to beat you up. Okay? If you harass them, if you are, it's another kid in school and you're following around and sending them these harassing emails and stuff, those are not protected by the First Amendment. Okay? So the difficulty is in drawing that line. Okay? Can some group on campus, for instance, maybe say, we oppose gay marriage? Gays on campus might feel like that's hate speech towards them. But do they have a right to express that idea? Could they express the idea that abortion is murder? I mean, this is part of our everyday political conversation. They've got to. But if they're threatening or harassing, it's not protected. Yeah?
My gauge is also, we're sort of set on law, like basic crimes, like the crime of assault.
Yeah.
I was wondering how you possibly would know how the government defends or differentiates like an assault as opposed to like the entertainment industry where we can view physical violence. And when two people on the street, how is it different when two people on the street consent to fighting as opposed to two people consenting and making money off of it in like the UFC industry and things like that?
So you're getting a little out of my range. Now, there's tort law, right? Tort law is the law that covers civil wrongs. So if I punch you, it's a battery. You could sue me for damages. Now, there are notions in there of consent, like for boxing and stuff like that. I don't know if, what the rules are for just two individuals who on the street want to start boxing with each other. But there are some notions of consent there. In terms of violence in the media, it is generally protected by the First Amendment. Oddly enough, one of the odd, weird things about our free speech jurisprudence is obscene speech. Speech that appeal to the prurient, to the lustful interest. If it's very strongly sexual, that in theory is not protected. They don't tend to enforce a lot of those laws, so it's everywhere. It's also, you can't stop it on the internet. But that's not protected. But violence against women, the test for obscenity is about its appeal to lustful interest, not violence. Violence is protected. Okay, that's how it's set up. It's kind of odd. Some countries like France, it's the exact opposite. The sexual stuff is protected. The violent stuff isn't. Who else? I got lots of hands here. Don't be afraid. Yes?
I was thinking, is the clothing you wear considered speech? And
The what?
the clothing you wear.
The clothing you wear could, okay, good. Look, one of the big questions when you study free speech is what speech? The word doesn't tell you. Obviously, words coming out of your mouth, written words. What about burning a flag? Is that speech at a rally? Is that expressive? So the court has recognized that conduct could be expressive. Could the way you dress be expressive? There have definitely been lower court decisions where kids have challenged dress codes, saying it violates their freedom of speech. Okay, so there can be if it wasn't expressive, people wouldn't spend an hour in front of the mirror every morning, right? So that is a potential argument. Okay, what else you guys got? Let me just ask you. Oh yeah, good.
I was wondering, I know there was a Wyoming case about the Amish, about there's a requirement that you have to get an education until you're about
Yes.
12th grade or so.
Yes.
And I think the Amish were able to get an exemption.
They were.
To continue education.
Yeah, okay, let me talk about that.
Like 8th grade. So I was wondering how that applied or how that connects to the general principle.
Got it. I even had a picture of an Amish there, so listen. This is Yoder, Wisconsin versus Yoder. Wisconsin, like a lot of states, has a law that says you got to send your kids to school until they're 16. Compulsory education, got it? With the Amish say our religion says we have to take them out of school before high school, have them work on the farm, and the stuff they live in the high school is not appropriate, got it? The law conflicted with religion. It was a free exercise issue. Now, and you're right, the Amish won, they got an exemption. Now there's a couple of things to note. One, that was decided before 1990 where they switched to the new rule that there's no exemption from neutral laws of general applicability. But the court in that case also said, but that's still a good case because it wasn't just based on their free exercise rights. There was another constitutional right at work, which is a constitutional right to control the upbringing of your children. They call it a hybrid case. So Yoder is good in that limited situation, but that was the case. Now let me ask you this. Okay, go ahead.
Going back to that, if this case comes back up now, could it be overturned since they have this new no exemption rule, or would it still say the same?
I mean, if another Masterpiece Cakeshop comes up, I don't think they got a good free exercise argument because non-discrimination laws are neutral law of general applicability. It's going to be the free speech argument. Now let me ask you this, okay? The case comes to you. You got to vote. Judges are not allowed to say, I don't feel like voting. The case comes to you. Jack Phillips, somebody like Jack Phillips says, you can't make me make this cake because it's in effect my endorsing same-sex marriage. It would violate my freedom of speech. The gay couple says, you can't discriminate against gay people. How many of you would rule in favor of Jack Phillips? How many would not? And then the rest of you didn't vote. But it was actually kind of even. It is a tricky issue. Okay? For me, it always keeps coming back to if he said, I can't serve Jews, I can't serve African Americans, I would say, forget about it. And then I keep asking, why is it different for gays and lesbians? You know, because there's some line in the Bible, does that make a difference? That's my sense. I'm inclined to say, suck it up, you have to do it. But it's hard to tell someone they have to do something against their faith. But remember, right? What Scalia said in that case with the peyotes, he says, if we start exempting everybody who says, my religion says I can't do it. I can't vaccinate my kids. That's an issue that's hot right now. Those are neutral laws of general applicability. States don't have to exempt them. Many do. Some are starting to get rid of them. I can't send my kids to school. I can't, my religion says I've got to have lots of guns, whatever it is. And Scalia said, that's anarchy. If any time a person says, my religion says I can't do it, the law won't be able to stop them. Tough cases. Anything else? All right, well, it's 3. That's the hour. Good. If you have any questions, I'll hang around, okay?